The Superior Court of California would like to welcome you to the Probate Conservatorship course. My name is Sherry Cruz, and I'm a probate attorney with Riverside Superior Court, and I will be your instructor. This is the first part of a two-part course that will provide an overview of probate conservatorships. In this first part of the course, we will discuss probate conservatorship of the person. In the second part, we will discuss probate conservatorship of the estate. You will only need to view the second part of the course if you're seeking conservatorship of the estate. You should have a copy of the Probate Conservatorship Notebook. We will be referring to this material throughout the course. You can download an electronic version of the notebook at the link provided here. This is an informational class for proposed conservators. I will not provide you with legal advice, and we are not entering into an attorney-client relationship. If you need legal advice, you can contact your county's bar association for referral to an attorney in your area. Also, you may qualify for free legal assistance through a local legal aid organization. For more information about the legal aid organizations in your area, refer to the Conservatorship Notebook. A conservatorship is a court proceeding which allows a judge to appoint a responsible person or organization, called a conservator, to care for another adult who cannot care for himself or herself or his or her finances, called a conservatee. A conservator does not need to be a relative of the conservatee, and a conservatee may have more than one conservator. A conservatorship might be appropriate when an adult who you care about, your parent, spouse, adult child, or other relative or friend, cannot provide for his or her own needs, and you are willing and able to ensure his or her safety and well-being. There are three types of conservatorships: general conservatorship, limited conservatorship, and Lanterman-Petra short conservatorship, which is referred to as LPS conservatorship. A general conservatorship is set up for adults who, because of physical injury, dementia, or other reasons, cannot care for themselves or are susceptible to undue influence. These conservatees may be older individuals with limitations caused by aging, or younger individuals who have become seriously impaired. A limited conservatorship is set up for adults who have a developmental disability and are not able to fully care for themselves, but they do not need the higher level of care provided by a general conservatorship. Accordingly, the powers of the conservator are limited to allow the conservatee to be as self-reliant and independent as possible. For the purposes of a limited conservatorship, a developmental disability is a severe and chronic disability that is attributed to a mental or physical impairment which began before the age of 18. It can be either a congenital disability or a disability that is the result of an injury or illness during the conservatee's minority. Conservatees with solely physically handicapping conditions are excluded from limited conservatorships. The court will require a report from the local regional center in cases where a limited conservatorship is sought, or in cases where a general conservatorship is sought, but the proposed conservatee is developmentally disabled. If the proposed conservatee is not already a client of the regional center may need to establish a file for the conservatee in order to file a report. While limited conservatorship is typically appropriate for an individual with a developmental disability, the court may decide to set up a general conservatorship for someone with more extensive developmental disabilities. A limited conservator usually has less authority than a general conservator. As a limited conservator, you would have the authority to do only those things that were laid out by the judge when you were appointed. The judge decides which responsibilities the conservatee will keep and which ones the conservator will have. The letters of conservatorship and the judge's order appointing the conservator will state what the conservator is allowed to do. In contrast, a general conservator is empowered to act unless the judge has set limits on his or her powers as conservator. There is another important distinction between general and limited conservatorships. A limited conservatee is considered to be growing and developing, and the conservator should always try to make choices that will enhance the conservatee's self-reliance and independence. For example, choices made for a 25-year-old limited conservatee may differ from those made to help an elderly person suffering from dementia. The third type of conservatorship is a Lanterman-Petrus Short Conservatorship, or LPS conservatorship, named for the sponsors of the act that authorizes this type of conservatorship. LPS conservatees are people who are unable to provide for their own food, clothing, or shelter as a result of a mental disorder or impairment due to chronic alcoholism, but who cannot or will not voluntarily agree to treatment. The County Department of Mental Health must initiate an LPS conservatorship, but anyone may apply to the department to have it initiate the evaluation of an individual who may be a danger to himself or herself or others. Once a conservatorship is established, a third party, such as a relative or friend of the conservatee, may serve as the LPS conservator. Most often, a county's public guardian agency serves as the conservator in LPS conservatorship cases. An LPS conservatorship is the only type of conservatorship that can authorize involuntary civil placement in a mental health treatment facility. For each of these three types of conservatorship, you can petition for a conservatorship of the person and/or a conservatorship of the estate. This first part of the class will cover a probate conservatorship of the person. A conservatorship of the person involves providing care for the conservatee, while a conservatorship of the estate involves managing the conservatee's property and finances. We will address conservatorship of the estate in the second part of this course. Conservatorships are costly and time-consuming for the conservator, and they can severely limit the conservatee's independence. Before you pursue a conservatorship, you should explore whether there is a more convenient and less restrictive option that would still allow you to provide the desired level of care for your loved one. A conservatorship may not be necessary if the proposed conservatee voluntarily accepts assistance or has planned in advance for his or her incapacity. The court will consider whether the proposed conservatee planned for the possibility of incapacity and whether those plans are sufficient to meet the proposed conservatee's present needs. An advanced healthcare directive may be an alternative for conservatorship of the person. A durable power of attorney or trust may be an alternative for conservatorship of the estate. However, only a person who has legal capacity can create these plans. These instruments cannot be created after a person becomes incompetent. If the proposed conservatee has no assets to manage, and his or her only source of income is Social Security or veterans benefits, then appointment of a representative payee may be an alternative to conservatorship of the estate. A representative payee is a fiduciary approved by the Social Security Administration or Veterans Administration to receive and manage the income for an individual. Some public and private pension plans also allow for the appointment of a designated payee. If all the income and assets of a proposed conservatee are community property, the spouse of the proposed conservatee generally has a legal right to manage the property. If the spouse needs to complete a transaction that requires the signature of the proposed conservatee, the spouse may file a petition to obtain this authority from the court. If an adult without a conservator needs medical treatment for an existing or continuing condition which, if left untreated, would probably become a serious threat to the physical or mental health of the person, a petition may be filed with the court. The petition can determine whether the adult lacks capacity to consent to the treatment and can give designated person the authority to consent to a specific recommended treatment on the patient's behalf. You can make these types of alternative arrangements and avoid the expense of a court-supervised proceeding. However, these options do lack some of the benefits of the conservatorship, including court supervision, which can help prevent or put an end to the abuse of the conservatee. There are numerous disadvantages to the conservatorship process, and you should carefully consider whether a conservatorship is actually necessary. The process can be time-consuming and complicated, a source of stress and conflict between family members or between you and the conservatee, and it can be very costly, especially if there is discord in the family about the need for or who will be the conservator. However, there are also numerous advantages to the conservatorship process. The court process can ensure the safety and well-being of the conservatee by ensuring they receive proper assistance, including assistance with housing and ensuring the conservatee receives proper medical care if he or she is not able to provide it for himself or herself. It can stop or prevent the abuse of the conservatee, whether physical or financial abuse. Once a court order is obtained, it clarifies the rights and obligations of both the conservator and the conservatee. For example, if the court authorizes medical powers, the conservator now has the right and obligation to make medical decisions, taking that power out of the conservatee's hands. It can provide stability and order for the conservatee, especially in situations where there may have been family not in agreement with the care necessary for the conservatee. Finally, it offers court supervision and protection. If the court makes an order, it can be relied upon, and even if someone does not agree with the court's order, following it will not cause any issues for the conservator. If there are no orders, it is possible that the court could find actions taken may not be for the benefit of the conservatee, and the person taking the action could receive some sort of sanction from the court. In addition to considering the alternatives to conservatorship that could meet the proposed conservatee's needs, you will also want to assess whether you are able to fulfill the responsibilities of being a conservator. To help you do this, we will begin by discussing what your responsibilities would be as conservator, and then we will review some tools and questions you can use in assessing whether you have the time and resources to accomplish these duties. As conservator, you are the conservatee's fiduciary, which means you owe the highest possible duty of care to the conservatee. Whether you are self-represented or represented by counsel, you are expected to know the law and your responsibilities. As part of your conservatorship petition, you must read about and acknowledge your responsibilities. You will complete and file the duties of conservatorship and acknowledgement of receipt of Handbook for Conservators, Form GC 348. It is important that you read the Conservatorship Handbook, which is available for free online at the web address provided here, or for purchase in the clerk's office. Your responsibilities will include arranging for the conservatee's care, which includes ensuring his or her physical and emotional well-being and safety. Accordingly, you will make arrangements for the conservatee's living accommodations, medical and dental care, meals, clothing, personal care, housekeeping, transportation, recreation, and any special needs. How you perform these duties will depend on your assessment of the conservatee's needs. But remember, a conservator of the person is not responsible for managing the conservatee's finances or property. However, if someone else, such as a conservator of the estate or a trustee, is handling the conservatee's property and finances, the two of you must work together. Talk with this person to be sure that you make arrangements for care that the conservatee can afford. An important aspect of caring for the conservatee's well-being is the conservator's responsibility to respect and uphold the rights retained by the conservatee. When a person becomes a conservatee, he or she does not entirely lose the right to take part in important decisions affecting his or her property and way of life. The conservatee generally retains certain rights, including the right to ask the judge to change conservators or end the conservatorship, receive personal mail, be represented by a lawyer, directly control wages or salary, make or change a will, enter into transactions to provide for the necessities of life for himself or herself, or for his or her minor children, to control spending money authorized by the judge, and engage in other activities expressly allowed by the court. Also, a conservatee may, subject to a judicial determination otherwise, marry, vote, make his or her own medical decisions, and receive visits from friends and family. Conservatees living in a care facility have rights protected by a state law called the Patient's Bill of Rights. All conservatees have the right to be treated with understanding and respect, and to have their wishes and abilities considered. In fulfilling your responsibilities, you should always act in the conservatee's best interest, and you should make choices that support, encourage, and assist the conservatee's wishes and capabilities. One of the most important decisions you will make regarding the conservatee's care is determining where the conservatee should live. Based on the conservatee's needs, desires, and finances, you should determine what type of residence will be the least restrictive alternative. This means that you are charged with identifying the type of residence that will allow the conservatee to live as independently as possible, while still providing the level of care necessary to ensure the conservatee's safety and well-being. In determining the least restrictive living arrangements for the conservatee, the conservator should become familiar with the different types of housing available, which are independent living, home care, retirement community, assisted living, board and care, dementia care, intermediate care, and skilled nursing. Details regarding the level of care offered by each type of facility are available in the Probate Conservatorship Notebook. There are several other resources in the Conservatorship Notebook that will help you evaluate which type of care facility is best for the conservatee, including a checklist to aid you in assessing the conservatee's needs, a list of questions to ask when you are evaluating a care facility, and a list of ideas for how to ensure a conservatee's quality of life, whether the conservatee lives at home or in a care facility. When you evaluate the conservatee's housing options, remember 3 important points. First, if you move the conservatee to a care facility, you are still responsible for making sure that he or she gets proper health care, nutrition, grooming, social stimulation, and recreation. Second, placing a conservatee in a secured perimeter facility requires specific authority from the court. Third, if you decide to change the conservatee's residence, you may need to petition the court and/or provide notice to the conservatee's attorney, family, and others who are entitled to notice. You will need to fulfill different notice requirements depending upon whether you are moving the conservatee out of his or her personal residence and whether you're moving the conservatee to a new residence within or outside the state of California. Within 30 days of the conservatee's move, you must provide written notice of the move to the court and mail copies of that notice to the conservatee's attorney and the conservatee's family through the second degree. The conservatee's family through the second degree includes the conservatee's spouse or domestic partner, children, parents, siblings, grandparents, and grandchildren. To provide notice, complete Form GC-080, Post-Move Notice of Change of Residence of Conservatee, mail a copy of the form to the necessary parties, and file the form as well as attachment GC-080MA to prove to the court that you provided notice. If you move the conservatee out of his or her personal residence, in other words, the conservatee's own home, you must provide notice by mail to the conservatee's attorney, and the conservatee's family through the second degree 15 days before the move. Complete Form GC-079, Pre-Move Notice of Proposed Change of Personal Residence of Conservatee. To provide this notice, and Form GC-079, MA to prove that you have mailed notice to the necessary parties. File both forms with the court. The pre-move notice is in addition to the 30-day post-move notice that is also required. You must seek a court approval before you move the conservatee. You must seek court approval before you move the conservatee outside of the state of California. If you, the conservator, move, you need to provide notice to the court by filing Form MC-040, Notice of Change of Address or Other Contact Information. You must also mail a copy of the notice to the conservatee's family through the second degree. Form GC-348, which outlines your duties as conservator, and the Conservatorship What to Expect handout in the Conservatorship Notebook also explain your notice obligations when changing the conservator's residence. If there is a valid Advanced Healthcare Directive or Healthcare Power of Attorney designating a healthcare decision maker, that person will retain the authority to make healthcare decisions for the conservatee, despite the fact that a conservator of the person has been appointed. As conservator, you must respect the conservatee's wishes as indicated in the Advanced Healthcare Directive. However, during the conservatorship proceeding, you may ask the court to terminate such powers to avoid conflicts. In some instances, you must ask the court to grant you specific powers that would otherwise not be granted to you. As we discussed before, limited conservatorships are meant to allow the conservatee to retain as much decision-making power as possible. Therefore, in an attachment to the petition for limited conservatorship, a proposed conservator would have to request the power to do the following: fix the conservatee's residence or dwelling, access the conservatee's confidential records or papers, give or withhold consent for the conservatee to marry, control the right of the conservatee to enter into contracts, give or withhold medical consent on behalf of the conservatee, restrict the conservatee's social relationships and sexual contacts, and make all decisions concerning the conservatee's education. Even general conservators, who are typically empowered to act in an area unless the judge has specifically set limits on their actions, may have to petition the court for certain powers. For example, a general conservator must petition the court for the exclusive power to make medical decisions and for dementia powers, which include the power to place the conservatee in a secured perimeter or locked facility and consent to the administration of psychotropic drugs to treat dementia. In most cases, the conservator and the conservatee share the right to make decisions about the conservatee's health care. However, if the conservatee objects to a particular treatment, the conservator must either have the exclusive authority to make medical decisions or a court order authorizing the treatment in order to proceed over the conservatee's objection. However, in an emergency situation, the conservator has the authority to give informed consent for the emergency medical treatment of the conservatee, regardless of the conservatee's consent. No court order is required if the conservator acts in good faith and based on medical advice. An emergency situation is one in which treatment is required for alleviation of severe pain, or the conservatee has a medical condition which, if not immediately diagnosed and treated, will lead to serious disability or death. A conservator may petition the court for the exclusive authority to make medical decisions at the time of the initial petition or after the conservator's appointment using Form GC-380, Petition for Exclusive Authority to Give Consent for Medical Treatment. The court will grant the petition if the conservator shows that the conservatee has lost the ability to make sound medical choices. Even when you have the authority to make decisions regarding an aspect of the conservatee's care, such as providing for the conservatee's housing and visits with family and friends, there are certain actions for which you must seek court permission. Unless you have court approval, as conservator, you may not move the conservatee to another state, place the conservatee in a secured or locked facility, isolate the conservatee from friends and family without good cause, expend funds of the estate without approval of the conservator of the estate, approve sterilization for the conservatee, authorize the use of psychotropic drugs for the treatment of dementia, experimental drugs, or electroshock therapy, force the conservatee to receive mental health treatment if he or she objects, or place the conservatee in a mental health treatment facility against his or her will, and remove the conservatee from life support without court approval, unless the conservatee previously expressed his or her intent to not receive life support. Generally, it is best to err on the side of caution and seek court approval when you believe any decision may cause the conservatee's family or the court and its representatives to question the quality of care you are providing to the conservatee. For example, if you believe a family member may object to your planned decision to take the conservatee on vacation out of state, you would be well advised to notify the court of your plans and seek court permission, even though you have the power to make such a decision on your own. Now that we have reviewed the responsibilities of being a conservator, you can see that acting as conservator is a big commitment. Fulfilling your responsibilities as conservator will likely involve countless hours. You will spend a good deal of time arranging housing, investigating housing facilities, attending doctor's visits, obtaining and managing medication, evaluating and managing caretakers, ensuring proper meals, and organizing quality of life enhancing provisions and activities for the conservatee. You should take the time to think about whether you will be able to meet your responsibilities as conservator, in addition to your other responsibilities and time commitments. The checklist, What are the conservator's needs, in the Probate Conservatorship Notebook, will help you evaluate your proposed conservatee's needs and your corresponding responsibilities. Considering the following questions will also help you determine your ability and willingness to fulfill the responsibilities of being conservator. What effect will the conservatorship have on you and your family? What personal and family responsibilities will you have in addition to caring for the proposed conservatee? Do you have small children who require a lot of your time? Do you have enough time and resources to be a conservator? What are your employment hours? When will you be available to care for the conservatee? How dependent is the proposed conservatee on others? Do you need to provide transportation for the conservatee? Will you be able to meet your responsibilities as conservator? How inconvenient will it be for you to provide the services necessary to care for the conservatee? Do you live close by the proposed conservatee? What support services are already in place? And can you fulfill your duties to the court? Are there funds available to pay others to provide services you cannot personally provide? Before becoming a conservator, you should also determine whether you will be able to handle the emotional component of the job. You may have to deal with the proposed conservatee's lack of capacity, anger, rejection, and verbal abuse. You should ask yourself whether you interact well with the proposed conservatee and if you and the proposed conservatee have gotten along in previous years. Petitioning for conservatorship can also be an expensive process, and you should consider whether you have the financial resources to file the petition. Most attorneys will charge thousands of dollars just to prepare the petition and pay the filing fee. An attorney's fee will increase substantially if the proposed conservatee or other interested individuals contest the petition. Typically, the person requesting the conservatorship must advance all of the money necessary to establish the conservatorship, and then, once appointed conservator, he or she may request that the court allow reimbursement from the conservatee's funds. As conservator, it is your legal duty to care for the proposed conservatee, and you should make sure that you will be able to fulfill that duty without completely disrupting your life. Organizations in your community may be able to support you in the fulfillment of your responsibilities as conservator. Consult the Probate Conservatorship Notebook for a list of services such as meal delivery for homebound individuals, social activities for the elderly and disabled, and support groups and respite services for family caregivers. Now that we have introduced probate conservatorships and the responsibilities of conservators, let's walk through the process of petitioning the court to be appointed as a conservator. You can also refer to the General Probate Conservatorship Chart in the Probate Conservatorship Notebook for an overview of the conservatorship process. You are not required to retain an attorney to represent you in conservatorship proceedings. You may represent yourself. As a self-representative petitioner, you may qualify for free legal assistance. Refer to the Probate Conservatorship Notebook for additional information. If you choose to represent yourself, you may still want to consult an attorney regarding certain situations, such as when the conservatee or a family member opposes a conservatorship. You have questions as to whether you can be appointed conservator. Adult Protective Services has been involved. You think the proposed conservatee will physically harm himself or herself or others, or you are making a major decision affecting the conservatee's quality of life. To initiate the process of establishing a conservatorship, the individual requesting the conservatorship must file a petition with the court. An agency, relative, or non-relative may file a petition for conservatorship. The court will consider the best interests of the conservatee in selecting who will serve as conservator, and the conservatee, if he or she has sufficient capacity, may nominate an individual for the court's consideration. You will need to file the forms which are listed here and in the probate conservatorship notebook to initiate a petition for appointment as general or limited conservator. You can download fillable versions of these forms, either individually or as a form packet, on the court's website. To file these forms, you must take them to the probate filing clerk at the court. The clerk will file your papers and schedule a hearing date. If you bring an extra copy of your completed paperwork, the clerk can file stamp your copy and you can keep it for your records. You must pay a fee to file the petition, as well as a fee to have a court reporter at the hearing. If you cannot afford these fees, you may file a request to waive court fees. After filing these forms with the court, you must provide notice of the petition to certain individuals. Providing notice is an important part of the conservatorship petition process, and one that is often done incorrectly. Failing to provide proper notice is the most frequent cause of delay in the appointment of a conservator. To provide notice, you must arrange for someone other than yourself, who is 18 years old or older, to notify certain individuals and government agencies that you are seeking conservatorship. Notice gives these interested parties a chance to support or object to the conservatorship. Notice must be given to the proposed conservatee and all of his or her relatives within the second degree. Relatives through the second degree include the conservatee's spouse or domestic partner, children, parents, siblings, grandparents, and grandchildren. The notice for conservatorships, family tree, provided in the conservatorship notebook will aid you in identifying the conservatee's relatives through the second degree. All of these relatives must be given notice of the petition for conservatorship, regardless of the extent to which they are involved in caring for the proposed conservatee or the status of your personal relationship with them. Even if some of these relatives have not seen the conservatee in some time, and especially if you are not on good terms with them and have reason to believe they may contest your appointment as conservator, you must still provide them with notice of the petition. Depending on who you are serving, there are two methods by which you will provide notice: personal service and service by mail. The server must personally serve the conservatee with notice of the hearing. This entails the server, someone other than you who is at least 18 years old, personally delivering to the conservatee the petition for appointment of probate conservator and a copy of the citation for conservatorship at least 15 days before the hearing. Then the server must fill out the proof of service on page 2 of the original citation, and you must file it with the court. Serving the conservatee is mandatory, even if he or she will not understand the notice. The family members of the proposed conservatee may be served by mail. The server, someone other than yourself who is at least 18 years old, must mail a copy of the notice of hearing and the petition for appointment of probate conservator to each of the conservatee's relatives within the second degree at least 15 days before the hearing. Then the server must complete the proof of service on page 2 of the original notice of hearing, and you must file the original notice of hearing with the completed proof of service with the court. If a family member is in jail or prison, you must serve the paperwork in the same manner as any other relative. If you do not know where a family member is, you must conduct a diligent search. A diligent search may be accomplished in the following ways: contact other family members and ask if they know where the individual lives. Check with the post office for a forwarding address. Check telephone directories for the area in which they were last known to reside, or do an internet search for their name. If you are unable to locate the individual, prepare and file a declaration to inform the court of your efforts to determine the whereabouts of the family member and to ask the court to dispense with the notice requirement for that individual. You may also need to provide notice to the heads of certain agencies. If the proposed conservatee is developmentally disabled, your server must mail notice of the hearing to your local regional center 30 days before the hearing. If the proposed conservatee is currently a patient in or on leave from a state hospital, your server must mail notice of the hearing to the Director of State Hospitals or the Director of Developmental Services 15 days before the hearing. If the conservatee receives benefits from the Veterans Administration or is entitled to receive such benefits, your server will also need to provide notice by mail to the Veterans Administration 15 days before the hearing. The most common reason for a conservatorship to not get granted and for the hearing to have to be continued is failure to properly give notice. Follow the notice rules very carefully, or the hearing will be continued. Once you have filed the petition, a court investigation will be initiated, which must be completed before the hearing on your petition for appointment as conservator. A court investigator will meet with the proposed conservatee, may also call or write to the conservatee's relatives of the first degree, and may choose to talk to the proposed conservator and others. The investigator may also check to see if you have any criminal history. Based on these inquiries, the court investigator will produce a written report for the court, which will be mailed to you. The court investigation fee must be paid by the conservatee, or, if a conservator of the estate is appointed, by the conservator of the estate using the conservatee's funds. If the conservatee receives Medi-Cal benefits, the court may decide to waive the investigation fee. The court investigator plays an important role in ensuring that the court has the information it needs to decide whether or not to grant your petition. So it is essential that you cooperate with the court investigator and provide him or her with any requested information. When a petition for conservatorship is filed for a developmentally disabled adult, the regional center will make an assessment of the case and file a report with the court. This report must be received by the court before the hearing, which is why providing proper notice to the regional center is important. As you know, all proposed conservators must view this course before the hearing on the petition for his or her appointment. Proposed conservators must file proof with the court that they viewed this mandatory course. At the end of the course, we will provide you with a link to a certificate of completion verifying that you've completed the course. Please print the certificate and file it with the probate clerk at the court at least 4 days before the hearing. The court may appoint counsel to represent the conservatee. The court generally has the discretion to appoint counsel and will do so when it determines appointment of counsel would be beneficial to the conservatee. However, the court must appoint counsel for a conservatee when a proposed conservator requests dementia powers or a limited conservatorship. Court-appointed counsel will only represent the conservatee in his or her best interest, not the proposed conservator. In fact, court-appointed counsel may determine that a conservatorship is not necessary, or that the conservatorship is necessary, but the proposed conservator is not the proper person to be appointed to care for the conservatee. Generally, assuming the petition is proper and necessary, a conservator will be appointed at the hearing on the petition. The hearing may be continued, or in other words, delayed, if the court appoints counsel for the conservatee, if the court has not received a report from the court investigator and/or the regional center, if the petition is incomplete, or if the petitioner failed to provide proper notice to the conservatee or the conservatee's family. The process will also take longer if the proposed conservatee or other interested individuals contest the appointment of the proposed conservator. In order to be prepared for the hearing and to ensure that it is not continued, you should do the following. Review the probate notes for your case and correct any deficiencies of your petition at least 4 court days before the hearing. You can view the probate notes for your case and read an explanation of the purpose of these notes on the court's website. These notes are generally available 20 days prior to your hearing. Be familiar with the forms you filed and bring copies with you, including the proofs of service, the letters of conservatorship, and the order appointing conservator. Attend the hearing with the proposed conservatee. Both you and the proposed conservatee must attend the hearing unless the court excuses the conservatee from attending. The court will do so if the conservatee's doctor indicated on the capacity declaration that the conservatee is unable to attend the hearing due to medical incapacity. Cooperate with the court investigator so that they are able to complete their report and submit it to the court in a timely manner. When you attend the hearing, if the conservatee is with you, you may ask the courtroom deputy for priority in having your case heard. The judge will call your case, and you and the conservatee will stand at the table along with any of the conservatee's family or friends who would like to join you. The judge will ask you and the conservatee questions, and all other persons at the table will be given an opportunity to speak to the judge as well. Anyone interested in the proposed conservatee, including relatives, friends, or neighbors, are entitled to object to or support your petition. The judge will usually make a decision at the end of the hearing. If you're appointed as conservator, the court may sign the order appointing conservator. You should then take the signed order and the letters of conservatorship to the clerk's office to be issued by the clerk of the court. The letters of conservatorship are proof of your authority to make decisions on behalf of the conservatee. A copy of the letters of conservatorship should be provided to any person or entity that needs to be informed of your authority to make decisions. Letters of conservatorship of the person are most often provided to hospitals, physicians, pharmacies, medical insurance carriers, care facilities, skilled nursing facilities, and to fix the residence of the conservatee. Many banks, hospitals, and doctors will insist on a certified copy of the letters of conservatorship. Because the court charges for each certified copy of a document, it is best to ask a party requesting a certified copy of the letters of conservatorship to make a photocopy of the certified document and return it to you. Some entities that request a certified copy of your letters may want those letters to have been certified within a certain time period. For example, if your conservatorship was granted 2 years ago, the agency may ask that you obtain more current letters so that they can be sure that the letters are still valid. As long as the conservatorship is still in place and you are still the conservator, the court will issue new letters to you at any time, thereby assuring the agency that you still have the authority to act on behalf of the conservatee. In certain emergency situations, the wait to have a general or limited conservator appointed may be too long. Under such circumstances, an individual may seek a temporary conservatorship of the person and/or estate, not as an alternative to a general or limited conservatorship, but simply for a specific period of time until a permanent conservator can be appointed. Please refer to the temporary conservatorship chart in the probate conservatorship notebook for an overview of the process. In order to obtain a temporary conservatorship, the petitioner must show that there is an emergency or urgent need for the appointment of a conservator before the hearing on the general petition. Examples of situations warranting court appointment of a temporary conservator include: the proposed conservatee needs immediate medical treatment because of an accident or illness, the death or incapacity of an agent under the proposed conservatee's durable powers of attorney for financial management and health care, to prevent the proposed conservatee from continuing to enter into damaging or health-threatening activities, to appoint an interim conservator to fill a vacancy for an existing conservatorship that resulted from the death, resignation, or removal of the conservator, when money has been stolen from the proposed conservatee and more is anticipated to be stolen before the general conservatorship hearing. The court will not usually grant a temporary conservatorship for non-emergency situations, such as when one family member will not allow another family member to see the proposed conservatee. The proposed conservatee has been gradually losing capacity over an extended period of time and may need to be placed in a care facility, or the petitioner does not feel the proposed conservatee is expending money appropriately. The decision on a temporary conservatorship is not necessarily related to a decision on the general conservatorship. The court could find that a conservatorship is necessary after proper notice and investigation is completed, but may not find that there is an emergency situation that warrants the granting of a temporary conservatorship. You must file the forms for a general or limited conservatorship either before or at the same time that you file the forms for a temporary conservatorship. The forms required for a temporary conservatorship are listed here, as well as on the temporary conservatorship chart in the probate conservatorship notebook. You can download fillable versions of these forms on the court's website. In addition to the fee to file the general conservatorship petition, you must also pay a filing fee for the temporary petition. A filing fee schedule is available on the court's website. As with a general or limited conservatorship petition, if you cannot afford these fees, you may file a fee waiver. You must provide notice of the petition for temporary conservatorship to the conservatee and his or her family, but you may not serve these documents yourself. Someone other than yourself who is at least 18 years old must complete service. The server must personally serve, or in other words, deliver, the notice of hearing and a copy of the petition for appointment of temporary conservator to the proposed conservatee 5 court days before the temporary conservatorship hearing date. The server must then fill out, and you must file, the proof of personal service of notice of hearing. The server must provide notice by mail to the proposed conservatee's relatives within the 2nd degree, the conservatee's spouse or registered domestic partner, parents, grandparents, children, grandchildren, and siblings, 5 court days before the hearing date. Once the server has served the notice of hearing and a copy of the petition for appointment of temporary conservator on the conservatee's family, he or she must complete, and you must file with the court, the proof of personal service by mail on page 2 of the notice of hearing. The court in the county where you file your petition may also require you to provide telephonic notice of the proposed conservatee and to the conservatee's family of the hearing on the appointment of a temporary conservator. If so, your server may also need to complete a local form or declaration stating that they provide verbal notice to the necessary individuals, which you should file with the court. The court will usually set the hearing more than 5 court days from the date of filing. However, the court may require a court investigator's report to be completed before a temporary conservator is appointed, or if you have filed an ex parte application for good cause exception to notice of hearing on petition for appointment of temporary conservator, the court may choose to set the hearing sooner. When a temporary conservator is appointed, he or she is only appointed for a fixed time period, usually 30 to 60 days, and only until a permanent conservator is appointed or the petition for permanent appointment is denied. The letters of temporary conservatorship will show the date when the temporary conservatorship ends. After you are appointed permanent, general, or limited conservator, you must do the following. Within 30 days of the hearing, you must serve by mail the notice of conservatee's rights and a copy of the order appointing probate conservator with the judge's signature on the conservatee's attorney, and the conservatee's relatives within the 2nd degree, the proposed conservatee's spouse or domestic partner, children, grandchildren, parents, grandparents, and siblings. You must then file the proof of mailing with the court. Within 60 days of the hearing, you must file a determination of conservatee's appropriate level of care. The level of care declaration is an overall or general plan that should provide a complete picture of the conservatee's personal needs and financial means. Include an evaluation of the level of care the conservatee was receiving at the time the petition for appointment of conservator was filed, and the measures necessary to keep the conservatee in his or her personal residence. If the conservatee was not living in his or her personal residence at the commencement of the proceeding, the determination of the appropriate level of care must include either a plan to return the conservatee to the personal residence or an explanation of the reasons why the conservatee cannot return to that residence in the foreseeable future. In most situations, you should be able to conduct the personal needs assessment without professional help. Nevertheless, you can ask for help from the conservatee's doctors, nurses, social workers, neighbors, family members, friends, and community agencies in trying to figure out how well the conservatee can carry on daily living activities. The court will schedule a review hearing to ensure that you have filed the notice of conservatee's rights and the determination of conservatee's appropriate level of care. The court will vacate the hearing if you are in compliance with the filing requirements. However, if you are not in compliance, The court may set a hearing for you to show good cause why the court should not remove you as conservator or impose a fine for your failure to complete and file these documents. After appointment, you must cooperate with the court investigator, who will regularly review the conservatorship. The court investigator may, at the discretion of the court, visit the conservatee 6 months after the hearing. A mandatory review will be scheduled around 1 year after the date of appointment. After this, visits will occur every 2 years, unless the court determines that reviews should be conducted more often. It is not your responsibility to initiate these reviews, and all visits will be unannounced. The court will review the investigator's report regarding the appropriateness of the conservatorship and whether the conservator is acting in the conservatee's best interest. Investigation review hearings are open to the public, and any interested person can attend the hearing. You are not required to attend an investigation review hearing unless the court orders you to appear. For each of these review visits, the court will charge an investigation assessment fee, which is to be paid out of the conservatee's estate. This fee may be waived if the conservatee is a Medi-Cal recipient. If the conservatee is not a Medi-Cal recipient but cannot afford this fee, an application for a fee waiver can be filed with the court. Once you're appointed conservator, you may be reimbursed from the conservatee's estate for the cost of establishing the conservatorship. Remember, you may not use the conservatee's money to pay for the conservatorship petition process. You must pay for all costs, like filing fees, court reporter fees, and attorney's fees, and then seek reimbursement once you're appointed. If you are appointed conservator, you may reimburse yourself for the petition filing fee and court reporter fee. However, you must seek a court order to reimburse yourself for your attorney's fees and other costs of establishing the conservatorship. If the petition for appointment of a conservator is unsuccessful, please note that the unsuccessful petitioner might only be compensated for fees and costs if he or she can show the court that the filing of the petition was in the proposed conservatee's best interest. Several situations may arise that will bring an end to the conservatorship or require the appointment of a new conservator. The death of the conservatee or termination of the conservatorship by court order will end a conservatorship. If the conservatee dies, you should file a copy of the death certificate with the court in order to notify the court that it can terminate the conservatorship proceeding and discontinue future investigations. Any person may petition the court for termination of a conservatorship of the person and/or estate. A conservator's status as conservator is terminated if he or she dies, resigns, or is removed by order of the court due to incapacity or for not acting in the conservatee's best interest. However, the death, incapacity, or removal of the conservator does not terminate the conservatorship. A successor will usually be appointed. Grounds for removal of a conservator include negligence, failure or inability to perform duties, felony conviction before or after appointment, gross immorality, conflict of interest, or abandonment of the conservatee. The court also has the authority to remove a conservator if it would be in the best interest of the conservatee. You have completed the probate conservatorship of the person course for proposed conservators. If you have any questions regarding your conservatorship petition, you may contact your court's probate department. However, keep in mind that probate staff may only speak with you regarding procedural matters and will not give you legal advice regarding how to handle your case. Thank you for your time and attention.